Thank you, Senator Gallagher. Senator Fawcett.
Thank you, Mr Acting Deputy President. I too rise to speak on the Social Services Legislation Amendment Bill of 2015. There's been a lot of discussion around the implications for people with mental illness, and I understand that because it's a serious issue that our community needs to address. But there are also some issues of principle that at a macro level our Federation is starting to try and come to grips with in a intelligent and considered manner with the Federation White Paper, looking at who pays for what, where should accountability lie. And to a large extent this debate falls into that category of how do we shape our Federation, the interaction between federal authorities and state authorities, when it comes to payments and support for people, whether they be people who are inside or outside of a mental health institution or a prison system, or in fact any other part of our society. And so my comments today are going to be largely around the factual nature of the bill, but also the principles that underpin it. And so firstly, the principle that applies here is that we're talking about social security payments. And social security payments, such as the disability support pension, are intended as a safety net for people who are in need. So whether somebody is unemployed, whether they can't work because of disability or some other reason, this is a payment from the federal government that is intended to provide for their basic needs so that they can provide the things, food, accommodation, etc. So these payments are not, according to the department, to be made where a person is confined under state and territory law and their basic needs, such as food and accommodation, are being met by the state or territory. And that's currently the case, for example, for somebody in prison. So if you were somebody who was receiving social benefits and you ended up in prison, then because the state is providing for those basic needs for you, then you cease to receive those payments from the Commonwealth, which are social security payments. And so whether it's a corrections or health or residential mental health services, being a state and territory responsibility, they are the ones who are responsible for paying those costs. So the government understands that those supports are there for while people are either incarcerated or receiving care. But we also understand that when people are looking to transition back into the community, that they do need support beyond just the basics, and that's why the government has made provision in this legislation that there are provisions in the bill for the circumstances where a person is not taken to be undergoing the psychiatric confinement, and so that means that the person will receive their social security payment during the period that is a period of integration back into the community for that person. So we recognise that there will be a period of crossover where they may spend some time or even the majority of time in the institution, but they are going through that period of reintegration and they need support beyond that, which the state or territory government is responsible for providing while they are in that institution. And so the government is trying to apply a broad principle here of who is responsible for looking after the individual during their period of confinement, who is then responsible to look after the individual or support that transition back into community, which is an important element for somebody who's suffering with a mental health condition, so that they can receive the support they need from community, from professionals, but also have the means at their disposal to assist that transition back. So at a principle level, the support this bill aligns with where the Federation is seeking to go in terms of better align responsibilities between the federal government and state and territory governments. Specifically, the amendments in this Act go after subsection 23(9), para 9A, and it says that subsection 9 doesn't apply in relation to a person whose confinement in a psychiatric institution is because the person has been charged with a serious offence. It goes on to then define serious offences later, which I'll come to. And the confinement in the 9B, the confinement of a person in a psychiatric institution because the person has been charged with a serious offence during a period, that is a period of integration back into the community for the person, is not taken to be psychiatric confinement. And so there again we have that clear delineation between saying there is a period where the person is confined, and so the responsibility for support in that kind of institution is with the state government. It's not the purpose of a social welfare payment. And then we have the period of transition. So two very clear sections in this legislation that address the principles that we're talking about. Further, in terms of refining the group who this will apply to, Section 9E that was referred to before goes to the definition of a serious offence. And a serious offence consists of three particular sub-elements: A, a murder or attempted murder; B, a manslaughter; or C, a rape or attempted rape. And Section 9F goes on to clarify that an offence is also a serious offence if A, it's an offence against the law of the Commonwealth or in a state or territory punishable by an imprisonment for life or a period or maximum period of at least 7 years; and B, the particular conduct constituting the offence involves 1, the loss of a person's life or serious risk of loss of a person's life; or 2, serious personal injury or serious risk of serious personal injury; or 3, serious damage to property in circumstances that endanger the life of a person. So we've defined a fairly small group in the Australian population who this applies to, and that actually gives lie to the comments opposite, that this is all about cost saving, because it is a small group and it's not a large cost. So it's an issue of principle that's being applied here, as opposed to any mean-handed cost-saving measure as the sole purpose. Importantly, if you go to the Statement of Compatibility with Human Rights, what we see is that, and I'm just looking for the actual comment here, in the explanatory memorandum it concluded that the legislative instrument doesn't give rise to a human rights concern because the people in psychiatric consignment receive benefits in kind in lieu of a social security payment by having their basic needs provided for by the relevant state or territory government. Additionally, the partners or children of people in psychiatric confinement are adequately provided for under existing social security arrangements. And so again, it comes back to this principle of providing care to the people who need care through the appropriate mechanism. So in this case, the person who is confined is receiving that care via the state or territory government, but for other dependents, family, children, the federal government still provides support through social welfare, because that is the purpose of social welfare, to provide for those people who have no other means of providing for their care. So this is consistent with the intent of the bill, which is to apply this principle of making sure that the appropriate responsibility and payments are met. There has been some concern raised that the cause of just removal of pension is triggered by a mental health order, but it's clear from the department's submission that the removal of payments is not triggered by the mental health order themselves, but whether the cause of the mental health order was a criminal charge for a serious offence. And so there has been consultation with the states and with Centrelink about the mechanisms for this. There's actually a fairly small number of institutions around Australia where these provisions would apply, and the department has made clear in their submissions, or highlighted in the committee examination of this, that there are appropriate measures in place to use the trigger of the charge as opposed to the mental health order. The department also explained that providing a distinction between serious and non-serious offences was to protect the continued payments of social security for people who hadn't been charged with a serious crime. Now, it's more likely that those who haven't been charged with a serious crime could be entering that transition period sooner, when we've already seen that there are provisions made for people to receive payments to assist with that transition. The Department highlights that the distinction between serious and non-serious crimes protects those people with a disability who are charged with less serious offences and yet are confined. It is acknowledged that in rare cases certain individuals who have been accused of lesser offences may be confined for extended periods because there are not suitable services to support them in the community. But the government recognised that that's an unusual case as opposed to the more serious offences where it is expected that people will be confined for a much longer period. So the Social Security Act of 1991 currently restricts payments to a person in psychiatric confinement as a result of being charged with an offence. But what this bill does is it amends the law to expand the eligibility of payments to people in psychiatric confinement who have not committed a serious offence. So that means that we're actually providing more access to people who are likely to be entering that transition period sooner so that they get that support. The part about cost shifting that has come up is important to consider in that at present people who are inpatients in that kind of a scenario are often charged up to 85% of their Commonwealth payments by the state and territory mental health institution. What we see is that a number of organisations presenting to the inquiry highlighted that they took payments from the people who were in detention. And we even had one case with Victoria Institute of Forensic Mental Health, Forensic Care, that outlined that their organisation did charge fees during a period of 2012-13. And so people who'd been there for more than 30 days were asked to pay between 75 and 80% of their pension. Now that was challenged by a patient, and Forensic Care did have to actually cease those fees because of litigation from a patient, and part of the settlement was that they ceased those fees. So what we see there is that there is some contention, even within the courts, in terms of whether or not the federal government fees, federal government payments, should actually be going to the institutions paying for the care. And clearly the responsibility there for the payment of that care rests with the state institutions. And in fact, the submission from the Queensland Government Department of Health outlines that not only do they provide that care in terms of providing for the daily requirements of accommodation and food, but Queensland also provides an Indigenous allowance payment of approximately $42 a week to mental health consumers who have no access to social security benefits. So we see there that already state governments have recognised that there is an obligation of them to provide that support to people who are in those facilities rather than relying completely on federal government support. So, Mr Acting Deputy President, this bill is about the principle of saying who is responsible for payments. It's very clear that social welfare payments from the federal government are for providing support for people who have no other means of receiving that support. It's clear that state and territory governments have the responsibility of providing for those daily living needs of people who are under their care. And what this bill does is it provides certainty that the fact that people who are in long-term situations, that we go back to the original intent of the legislation, which was in place before the 2002 court decision, which changed the rules, and it goes back to say that those people who are there long-term, that they will be provided for by the provisions of the state and territory government when they are at the point where they are looking to reintegrate with community, or if they're likely to be there for a shorter term, as in a less serious offence, then the federal government will continue to make those payments so that it optimises the reintegration outcomes for people who are going to come back into community. This is not about penalising people. This is not purely about cost savings. This is about an attempt to make sure that in our federation the relationship between the states and federal government have a consistency, a continuity in the way that we support people, and that we make sure that we don't have overlaps between levels of government. I commend this bill to the House.
Thank you,